this episode, I'm going to speak about making a will and making what is called a lasting power of attorney. I've often talked to my clients, and most of them I've realized they do not have a will or are reluctant to have a will. I've spoken to my clients who normally originate from outside the UK, and some have got views that are not fair when it comes to wills. Some believe that it's not necessary to have a will. Some think that it's superstitious to have a will. It might bring death upon them if they make a will, but that is completely unfounded. The most frightening thing is that when these people pass away, especially my clients who come outside the UK, particularly from countries from Africa, when they pass away, families start fighting because they've not left a will, and their estate is going to be distributed according to cultural terms which they believe, or it's going to be distributed according to what the law of their own country, which might not be favorable to their own family. I always encourage my clients, particularly my diaspora clients, that they need to have a will to cover for their property that is in the UK, that is in their home country. It might be Zimbabwe, South Africa, Angola, Nigeria, or whatever country which they come from, to have a will so that when they pass away, their properties are distributed according to the will. So the first thing that I'm going to tackle is what is a will. A will is a legal way of making your intentions and arrangements of how your estate is going to be distributed known to the people who distribute your will, your estate. The will can also take care of your care arrangements and the care arrangements of your children and your dependents. And you might also be able to appoint someone who will be able to look after your children when you pass away. There are various types of wills. We have got a single will, which is suitable for someone who's a single individual who's looking to record their own wishes. We have got wills that are called mirror wills, which are suitable for couples, and which have got almost the same provisions in the wills, and which makes distribution of the wills or the estate nearly the same in what they're distributing in terms of the estate. We also have trust wills, where you can create a discretionary will where you can leave your estate to your children or to your beneficiaries in terms of a trust, and you appoint some trustees who will be managing the will. And we can also have a property trust will, where you leave your property in a will. You might have one property, you might have one house, and you've got several children, and you don't want to give that house to a particular child, but you want your children to inherit the house in equal shares or whatever shares you want them to have. So that might be the best way to distribute your estate if you leave it in a trust will. In your will, if you are married, you can leave a life interest to your partner or your husband or your wife, so that they can live in the property for the rest of their life, but they cannot be able to dispose of the property, and the property can be left for your children once that partner either passes away or they get remarried. So they just have an enjoyment of the property during their lifetime, when they are still single, or until when they pass away. If you are not so sure of the type of will that you can have, we can provide you professional advice, and we can help you having had a look at your circumstances, and we can advise you on the proper will that you can have to cover you. A person who dies without a will is said to have died intestate. And when you die intestate, your estate is distributed according to intestacy laws. You do not have control of what's going to happen to your estate. You do not have control of the beneficiaries who are going to benefit from your estate. If, for example, you are in an unmarried relationship, your partner might not benefit, or your stepchildren might not benefit. So it is important for you to have a will so that your loved ones, your close people, can be able to benefit from your estate. If you die intestate, then an administrator is appointed. If you die um, with a will, then you've got an executor who will be distributing the estate on your behalf. One of the challenges that my clients face is that they might have properties in multiple jurisdictions. They might have a property in the UK, they might have a property in Zimbabwe, South Africa, Nigeria, or Ghana, or Australia. And they ask me, is it possible to just have one will? While it might be possible to have one will, it is advisable, in my view, to have multiple wills if you have multiple properties in different jurisdictions, because each jurisdiction has got its own laws on wills, and it has got its own laws on the distribution of properties, on probate and things like that. So you need to have different wills if you are having properties in different jurisdictions, but just being careful that your wills do not clash with each other but complement each other. Now I want to move on to the topic of lasting powers of attorney. A will becomes effective when you die. So that's when your will, people will get your will, and then they will have to distribute your estate according to the provisions of the will. But when you are still alive, it is also important for you to consider having a lasting power of attorney. A lasting power of attorney is a legal document that grants another person authority to make decisions on your behalf if you are unable to make these decisions yourself. There is mainly two types of lasting powers of attorney. There is the health and welfare lasting power of attorney, which allows you to name people you would like to make your decisions about your health care, medical treatment, and living arrangements if you are no longer able to voice your own opinion. If you do not have this health and welfare lasting power of attorney, then that decision and power is left to your medical team, who might include your GP, your consultant, to make decisions, and the opinions of your family might not matter because you don't have a lasting power of attorney. The second type of lasting power of attorney is a property and financial affairs lasting power of attorney, which allows you to name people who can deal with any money or property that you own in England or Wales if it's no longer practicable or possible for you to do it yourself. It is important that you register your lasting power of attorney with the Office of the Public Guardian before it can be used, and try to register it at the earliest convenience. So what happens if you don't have a lasting power of attorney? Your family and loved ones may be unable to conduct your affairs on your behalf. Your family might be unable to decide on the treatment or medication best for you, and the decision may be left to your medical personnel. However, even in such situations, the court can still apply to the court for a deputyship order. This is a very expensive process, and it might take several months to get a decision from the court. And in that meantime, events might have happened that might not be so pleasant, and you might have passed on, or you might have been given treatment which you were not supposed to be given, or which your family didn't want you to be given. Even so, it is up to the court to approve the application, which can be challenged by other family members, or even so by the medical teams if they do not believe that the court has made the correct decision. And you have also to consider that there is also costs that might be involved, such as court fees, solicitor fees, barrister fees, experts, and fees and disbursements that needs to be dealt with. Why is it important to have both a will and a lasting power of attorney? One way to prevent the previous mentioned challenges is by having both a will and a lasting power of attorney. Having a will without a lasting power of attorney, your family finds itself powerless to take care of you if anything happens in your lifetime. If you have a lasting power of attorney without a will, then you do not have control of what happens to your estate when you pass away. At Tanlo Solicitors, we have got partners who can also be able to help you with the registration of wills, with companies which do register wills, so that when you pass away, a search can be done on a national register and your will can be found there. In case your relatives cannot find a copy of your will, and if it's registered, then it's easy for them to know that you've got a will. Because some people die with a will, but it's never located because of where it's, one, it's not registered, and two, it's not properly stored as well. We do have partners who store wills in a secure storage, and it is just by notice to them that the will can be retrieved. Both these partners, they do charge very cheap fees for the registration of the will and for the storage of the will. And we do have good deals with these companies, and as we are partners in the business. So if you require a will and if you require a lasting power of attorney, Tanlo Solicitors is your solicitors to assist you. Particularly maybe if you are someone who's coming from the diaspora, you have got properties in this country, the United Kingdom, England and Wales, and you have got properties in Africa or Australia or the United States. We have got well experienced members of the staff that can help you. Thank you.